judges are very good at ascertaining the credibility of a witness. Absolutely excellent. They know what to look for. They know what to look for in seeing whether a witness is lying or not. And often, a pointer to not lying is that they say when they can't remember. Oh, sorry.
But that's
whereas
where
people
your job
can make
comes.
it up.
Your job comes into play as a
cross-examiner, yes. And cross-examination
What
is good
are the
fun.
considerations that, because the feedback I've got from a lot of my clients is that you're very good at cross-examination.
Well, that's very kind.
So perhaps you can share your secrets with
I
others.
just shout at them. Shouting always
I
gets
don't think you've ever shouted.
Shouting always gets the best results.
Surely not. What are the other considerations? I've heard stories of barristers where they sat down with their client and they're playing hangman because leading the witness. Is that?
Yeah, in civil you definitely. In civil you don't really get this. I mean, I should explain what happens in all civil trials, but certainly in a small claims trial, is that the testimony of a witness is its statement. So, when you go to court and you're giving evidence, you will go with a witness statement, and this witness statement will be signed by you.
Yeah.
Now, in civil courts, that witness statement is their evidence. So you say to the judge, "What is your name?" and they go, "Mr. Bloggs," or "Mrs. Bloggs," or "Miss Bloggs," and then you say, "Is this your statement?" "Yep." "Is that your signature?" "Yep." Are the contents true?" "Yep." And then you say, "Sir or madam, can this statement stand as their evidence?" And invariably the judge will go, "Yes." Now in criminal cases, of course, that's not the case. Criminal is an oral court. So the evidence in chief, which is the claimant's own testimony, you have to get that by a series of questions, and that's where you can't lead. You cannot lead in questioning the witness over its own evidence.
Okay.
So if you're giving testimony now, I can't say, "In that interview with Robert Mackenzie, what did you say?" I have to get you to the stage where you tell me there's an interview. Mm-hmm. So it'd have to be something like what happened on the first. Can you remember what happened on the 30th of September? Yeah. Now this is where you can't ask leading questions. In cross-examination, at least 70% of your questions will be leading questions, and they're expected to be leading questions. Certainly when you're putting the case. Mm. I mean, in big cases, your big barristers will try to get the person whom he's cross-examining to trip themselves up.
Yeah.
So he will ask open questions.
Hangman analogy comes from.
Yes.
One question, then another question, then they.
Yes.
That's where it comes from then.
But actually, somebody once said, the great man said it is. But at the end of the day, I don't think much is won in cross-examination. I think it's evidence in chief. I think it's their own evidence, and also the judge will have their own questions usually. Mm. I don't think that much is won in cross-examination.
Okay, but having said that, if you can show the witness to be a liar,
yes, yeah,
that would be very damaging.
Yes,
and you looked at an issue, and the issue was that their defence was based on the fact that they alleged the contract had been varied, had been changed. Because they said that the recruitment agent had agreed to find another candidate free of charge, and you were very concerned. Would it be a small claim? Judges are pretty much judges unto themselves, and you were very concerned that the judge may rule in favour of the defendant on their testimony. Most certainly, when the witness that they said had made that representation was not available in court to defend it. So it's going to be their word against a witness that's not there.
Yes.
And you were very concerned about that, rightly so. You did disturb my breakfast, but at the same time I was working, and I made the point. I said, if you look at the contract, there is a clause in the contract that stipulates you can only vary the contract in writing.
Yeah. And which is what won the case.
Which is what won the case.
Yeah.
Again, the reason why you need good legal advice, well, not just legal advice, it's also down to experience on what to look for in the evidence.
Yes.
And that's what you do.
I try to.
You try to. So when it comes to evidence, what are the things that you look for?
No, but preparation is good, and the more detailed the witness statement, the better. And he wants to give witness statement wants to give a thorough explanation of what happened and the surrounding circumstances, and maybe put a bit about the law into.
Yeah, a little bit of sprint.
You don't want something bare and insubstantial.
Yeah. On the flip side, although you were persuaded by the witness testimony, you did not want to go before a judge where there was nothing to confirm what was agreed.
Yeah, so we settled, that's right, we settled it. And I did have slight concern about one of the witnesses.
What concern was that?
I'm not sure he remembered as well as he should have done, what happened.
Okay. Because the other side had said, we'd paid you, it'd been agreed.
I think it would have been a long day. You don't know which side the judge would have come down on, and we could have lost everything. Because, you see, nobody knows how a witness is going to react in front of a judge.
Yes, they can
crack. And cross-examination.
Yeah. And
they can crack, and what they say as certain before a hearing often proves to be, in effect, complete rubbish. And I had slight misgivings about how well this witness could recollect. And of course, barristers can't coach witnesses, so we have to leave it there.
Okay.
So
you thought the sensible thing would...
that yes, I think going to court should always be a last resort. Even when you're in court, settle if possible. Yeah. Because there is such risk in the courtroom.
You decided on this occasion, for the risks that you've just described, that it would be best to settle.
Yes, it was a reasonable
offer. And you settled on the day.
On the day, in court, before we got through the door.
Nevertheless,
the courtroom.
Nevertheless, because our argument was pretty much an unjust enrichment argument, which was we appreciate there's nothing in writing. We appreciate we didn't give a quote, but we delivered the goods and the services, and we deserve to be paid for it. And this is what we would usually charge. And what you ultimately assessed was, well, I think £3,000 is what a judge would assess.
Yeah.
Ultimately.
Yeah.
I had a similar case not too long ago where a builder tried to charge £1,500 to fit and supply a Velux window, and the judge said that is astronomical. It doesn't take a day to fit a window, and the judge made.
Well, it depends who you are.
One window. It was one window. It was one. You know, the Velux window was one window, Robert. The judge had actually said, agreed with the defendant. It doesn't cost £1,500 to fit one window. Bearing in mind that the defendant had also provided testimony that they supplied the window. So all they did was charge £1,500. So what we're saying in this particular instance, you made that assessment thinking, well, look, there's nothing in writing. We're going to go before a judge. The judge may well agree, yes, you did do the work. Yes, you did supply the goods. It's now up to me to determine how much you should be paid for.
Yeah. Yeah, I mean, I think the lesson from this is being 100% sure of your case before you go to court. Now, unfortunately, on this one, there was a quantum merit, but that's quite a complicated legal principle.
What is quantum merit for the viewers?
I think
in plain English.
I think you should describe that. You're the expert on quantum merit.
Well, quantum merit. Read my article on Master Collection's website. You see everything you need to know about quantum merit.
Yeah.
It was a pleasure having you in today, Robert.
Thanks.
And education, some fantastic information you've shared with our viewers. If there's anything in this interview of interest to you, please do get in touch. Our telephone number will appear at the end of the video. Remember, please like, comment and subscribe.